Hi, this is the 3 a.m. DUI series, Video 3, Arraignment. My name is Andrew Wheeler. I've been a criminal defense attorney here in Southwest Washington for the last 14 years, and for the last 12 years I've focused my practice on DUI defense. The intention of the 3 a.m. series is, again, if you've perhaps just been arrested for a DUI, it's late at night, you have court coming up and you can't sleep. The goal is to provide some value to you, some information that you could benefit from, and again, hopefully to answer some of the questions you may have. The arraignment process and the date is going to come to you specifically through some documents you may have received from the arresting officer. The first that's most commonly used here in Clark County is what's called an e-ticket. The e-ticket at the lower portion here is going to have a court date and a court time on it. That's your arraignment. Some of the law enforcement agencies use an older ticket where the officer handwrites things in. This is going to be found right down here, again, your arraignment date and time. Now, very often I'm receiving calls over the weekend from folks who have been bailed out over the weekend about when their court appearance is, because oftentimes it will not appear on the citation itself. For those folks, the general rule of thumb is this: if you were arrested by the state patrol or a local sheriff, those arraignments are on Mondays in Clark County. If it's a city case, those are generally on Tuesdays. So again, I encourage you to reach out to your local bail bondsman who posted the bail, verify the date, but that's kind of the rule of thumb that we generally go by. The morning of arraignment, my clients oftentimes meet me at the office, and I provide some of the same information as we're walking up to court. At the arraignment, the process starts. And the thing that I think that most folks struggle with when it comes to the arraignment is, in particular, hey Andrew, there's a breath test. I was driving. What are you telling me to do? What's the court going to say if I enter a not guilty plea? And I tell my clients with that not guilty plea to basically think of it like a placeholder. It's a bookmark. It's something that's going to hold your case while we're exploring your different options, the evidentiary issues, and such, trying to work towards a better resolution. Because you can't do the opposite. Meaning you can't plead guilty at the arraignment and go, gosh, I didn't see that jail time coming or that license suspension, and try to take it back. So the sense is you want to leave all those doors open, and the best way to do that is the not guilty plea. At the arraignment, the judge will review what's called probable cause, which is just a determination of whether or not there's enough information on file to proceed with the arraignment. And again, for my clients, I'm going to be up in front of the court talking, certainly entering the not guilty plea. And the other thing we can do is I get my first preview of the paperwork the prosecution is going to use. This is both generally the narrative and the DUI arrest report. The advantage of looking at these early is it gives us, again, a sense of what we're looking at. It gives my client some clarity on possible evidentiary issues, and it kind of tells me what direction we might be heading, at least from the arraignment process forward. Lastly, the court can set release conditions, and the release conditions fall into two main categories. We would call standard conditions or supervised conditions. Standard conditions are what most of my clients are going to have if they've never had a previous DUI. A standard condition would be basically, very simply, to maintain contact with your attorney, to come back at your next court date, and to not consume any alcohol, non-prescribed drugs, or controlled substances while your case is pending. In regards to court dates, you may be given one or two. If you're given two, you'll be given what's called a pro se date and a mandatory date. And the pro se date is a date only if you do not have counsel you'd come back. So oftentimes for my clients, I'll cross that pro se date out, and again, we're going to be coming back on that mandatory court date. The second type of release condition the client may have is what's called supervised release conditions. We're going to see supervised conditions in high breath test cases, perhaps circumstances where there's been an accident. Lastly, supervised release could be required per statute. The conditions, I would say, kind of have a spectrum. The lowest probably type of supervised release condition is what's called monitored ANTABUSE. ANTABUSE is a prescription medication you would take monitored at a pharmacy. Usually it's 3 times a week, and it makes you tremendously ill if you consume alcohol. The next level up from there is what's called random UAs and BAs. These tests, you're placed on a color line. Let's say my color is green. Every morning I would call this specific line to see if my color came up. If my color did come up, I'd have to provide a random breath test or urine test. The price point for this condition is slightly higher, about $45 per session. Most folks do it twice a month. The biggest concern with UAs and BAs in particular here in Southwest Washington is for my clients who work in Portland or maybe live in Portland and have to commute over to Vancouver to do it. As we all know, the traffic's not the greatest probably in the evening when this would be taking place. There are two conditions now that have come about primarily based on statute. Now, pre-2013, the judges always had discretion, meaning in some cases they could give tremendously high conditions, in other cases they could give lower conditions despite a person's criminal history. The sense is now, though, if you have ever had a previous DUI, or had a case that started as a DUI that was amended down, the court is required to place one or two possible conditions on you, or theoretically both. The first would be what's called an interlock device. This is a device that will be installed in your vehicle, has to be done within 5 business days, and the vehicle will not operate or run if you have alcohol in your system when you blow into it. The biggest concern when it comes to interlock for my clients is the installation process. It's really difficult to get the actual device installed within 5 days. So what I tell my clients is for supervised release, at least here in Clark County, just make sure that you have an appointment scheduled within those first 5 days. Now, the condition we really want to avoid if we can is a condition called a SCRAM monitor. A SCRAM monitor is a transdermal alcohol monitor. It sends a reading every 45 minutes and has a much higher price point. A SCRAM monitor, depending on my client's income, is going to run between $13 and $30 per day, whereas the interlock device is about a price point of about $15 per week. So as you can imagine, if my client does have a previous DUI, we're going to have a discussion fairly early on about why an interlock device is a much more advantageous, both in terms of convenience and a price point, than something like a SCRAM monitor. Finally, at the conclusion of the arraignment process, I come back and I debrief my client on exactly what's happened. My hope is that you found some value today in our discussion of the arraignment process in Southwest Washington, and please feel free to give me a call if you have any questions.